Okay, my name is Dr. Magare Gikenyi. I'm a consultant trauma and general surgeon. In addition, I'm also a human rights defender or a constitutional defender. So today we are discussing on the issue of a petition in which we filed, Petition 1 of 2026, which is essentially we wanted that the court to bar the county government, national government, independent institutions, and all our public entities from employing or hiring, essentially engaging private lawyers when we already have state councils. So we filed it before Nakuru High Court, and on 12th of this month, 12th January 2026, the High Court sitting in Nakuru granted us conservatory orders directing all public entities are not allowed to procure private legal services when they already have county attorneys and state councils. That was done. Then following that, the LSK and other respondents filed an application to set aside the impugned orders. Today we are having the hearing. We wait for a ruling on another date. So one may ask, what's the basis of that? The basis of our application is based on Article 156, Sub-Article 7, which requires that the Office of Attorney General can represent the national government in court or other legal proceedings through herself or through other state councils. Through that in itself does not allow private legal advocates to be enjoined or to be engaged in the public service. Because if you read that with Article 201 on prudent use of financial resources, it means then it does not make sense and is self-defeatist. For us as Kenyan people, we use money, we advertise, we get the best advocate, a state council and county attorneys, and we pay them to do their work. Instead of doing their work, we move out and move the next external advocates. That's number one. On the county government, the county government are also allowed by law to have what we call county attorneys. That's why we have a County Attorneys Act, Cap 265E of the laws of Kenya, which allows the county attorney to represent the county government in courts or legal proceedings. So that's what that's the law says. In addition, it also says, in the unlikely event they don't have the capacity to do that, they can request the national government through the office of the Attorney General to represent it through Section 43 of the County Government Act 2012. Which means essentially there is no reason why a county government should not have internal lawyers. Because currently they even have it, but in addition to having them, they have intentionally made them not either to have it or have those the county attorneys, but use external lawyers. There's no personally, I don't have any personal problem with any advocate or lawyer. The only thing I'm saying is about the prudent use of financial resources. The legal profession or the advocates justify their inclusion based on one among other issues that they are procured they are allowed what they call procurement of legal services by pursuant to Article 227 of the Constitution. However, the same article says when doing that, you must have competitive, merit-based and cost effectiveness of doing those procurement. It is not cost effective for us as Kenyan people to use our money, advertise, employ county council, we pay them. Instead of using them, then we move outside. They also say that in addition to that, every county government or any public entity has a right of representation as provided in Article 50 of the Constitution. That is true. I agree with them. However, to some extent, you cannot claim the right of representation when as public entity you advertise, thousands of people apply, you pick the best to represent you. You employ them. But then when they want to represent you, they say, oh, I have right of representation. Those people are employed, they are not very sharp. They lack legal expertise. Let me look for private lawyers. Well, then one wonders, why do you employ people who did not sort out your issues? So those are the things we are discussing now. Then the argument is, as you read Article 259 of the Constitution, it must have purposive interpretation of the Constitution, which means one constitutional provision does not kill the other, it supports the other. If you look at Article 201, it is about prudent use of financial resources. As a general rule, public resources are not ubiquitous. They are scarce and they are not ubiquitous. So which means the scarce public resources, we need to use them well. If you realize the pre-2010 Constitution, the public service was in chaos. Person X used to earn 2 shillings, others 10 shillings, but the same level. You can have people whom you graduate the same today, you graduate the same class, the same school. One is earning, all of you are in public service. One is earning 100 shillings, you are earning 50 shillings. In effort to curb that, the people of Kenya, in their wisdom, brought about the SRC, established a commission called Salaries and Remuneration Commission. This one, what among others, it talks about physical sustainability. We must have our physical budget or wage bill needs to be physically manageable. But then, to avoid the SRC, the respondents, in their view, the national county government, they have now bypassed the SRC through the procurement limb, which in my honest opinion is against the constitutional provisions. Article 10 requires us to have good governance and fairness and equity. We cannot do that. And Article also 273 says that talks that the public officers are engaged or they are in that office on behalf of the Kenyan people. So you cannot use the office to enrich yourselves. That's why even us, I'm not saying about lawyers, all of us, if you realize, even the medical profession, if for example for any reason, like in our place in Nakuru, we have a case which requires extra expertise. What do? We refer the patient to that hospital. For example, if we need serious, we refer to level 6, like Kenyatta National Hospital, Moi Teaching and Referral Hospital, among other specialized aspects. But even then, even if we were to assume there are no expertise even within KNH can still hire private doctors, but when they come with the SRC rates. They don't come with the private rates. In medical field, there's what they call KMPDC rates, Kenya Medical Practitioner and Dentist Council rates. For example, if you have cancer of the pancreas, head of pancreas, we do a procedure which is called WIPOS procedure. It's a fairly specialized procedure. It's not found in anywhere. So what happens if you do in the private, you can be paid, their KMPDC rates is around 300,000 to 500,000 in the KMPDC rates. But in government, when you come to do any work in government, you will come and you will be remunerated as a public service rates. You will not use the private rates. But in the legal profession, if you engage a lawyer, he will come, but they will come, he will not, the rate is being paid will be due to public service. Will not be due to public service rates. He will come with their own rates, what we call the IRO, Advocate Remuneration Order, which is a special legislation created by virtue of Section 44 of the Advocate Act. If you see that aspects, for example, you check the 50th schedule of Advocate Remuneration Order, it says that the advocate, once employed, he can decide how much he gets paid based on complexity and other circumstances of the case. Nobody knows how the complex is, nobody knows. But for example, if I told you, for example, WIPOS procedure in the medical field is very complex. But when you come the medical field, if you do any surgeries, you will be paid at the number of days, not even the complexity. For example, they will rate you, if we would have employed you, how much you would have paid you. For example, a senior consultant, you will be paid between 300,000, for example. And you have worked in this hospital for 15 days. That's half a month. Even if you do those complex cases, 100 of them, but you have worked for 15 days, you'll be paid for 15 days which you have worked, which is 15 out of 30 times that amount, which is 300. You get 150,000. But you ask, there's nowhere whereby in the public service where somebody's supposed to decide how much is being paid on himself or herself based on complexity or other circumstances of the case. So those are the issues. For example, you compare like the county of Nakuru, where I come from. We have 503 million is used for legal services. 540, that's half a billion for legal services. If you could have employed legal state attorneys and solicitor, county solicitors, it would be so much less. $1 million si pesa kidogo, and you realize $1 million is a lot. So the case we are using 543, I think it's 543 years, 543 million as legal fees. Then what will happen? My aspect, I'm just saying we need how public finance need to be accountable. That's what we are saying. There must be accountability by virtue of Article 201 of the Constitution. That's where we have reached. So that's how we are saying, let us have a prudent use of financial resources. But in addition to our argument, what we are also arguing is like, number one, this report, they not just land from the sky. This is the reports which were filed by the Office of the Auditor General, pursuant to Article 229 of the Constitution. The same was also reported by the Control of Budget. So whatever I'm saying, this amount I'm saying, is not my figures. It's the official independent offices, which is the Office of the Control of Budget and the Auditor General. So which in itself means they have seen there's a lot of gaps. They have even questioned the wisdom of having county attorneys, state councils, but then we always go on. Like, for example, in the airport, they had done a deal. A legal firm was paid $243 million for one case. That's $250 million for one case. And then we say we don't have money. If we misuse this money, where will we get money for our school children? Where will we get money for our roads? Where will we get money for our health care? We need social services. We need education. That's why we always say we need to have a prudent use of financial resources. And that's why we are saying that as a matter of fact, we are not asking anything out of the ordinary. We are saying let us have prudent use of financial resources. Nothing personal, nothing. And I've always said I have no personal problem with advocates. Because even us in the medical field, if we had that arrangement, even like me and my surgeon, if we have an arrangement where private surgeons come, they do surgery in the government, but then they are paid by private rates. Still, I would have moved to court. Because why I say that, a wrong is always a wrong. It does not matter who does it. That's what we're trying to put across. That's what I was saying. As a country, we need to have what we call a national conversation. That we need to have what we call prudent use of our financial resources. We cannot use money as if and then aim to reach Singapore. You can never be Singapore when you are misusing money. In any case, a constitutional provision does not allow you to circumvent good intention of the Constitution. It was never meant, a Constitution was never meant to have a provision which circumvents it. Otherwise, we will never move forward as a society. That's what we're saying. For example, if you're in public, be public. If for example, you're a public officer, and then you do private work, as far as you do private outside the official normal working hours, there's no problem. But when you move from private to public, let us pay you. If it's a must, we pay you. We pay you using public service rates. That's what we're trying to put across. For example, if the private lawyers want to come to government, they are free to do it. There will be an advertisement, they apply, those who are selected, they get employed, and life moves on. But at the same time, you cannot be in private, then back to government. You have to choose one. Of course, there are the people who say, oh, even doctors get locums. Yes, we do get. But the public service always says that before you get a locum doctor, you have to advertise. There's no shortcut of that. You have to advertise. People apply, you choose those people you want for locums. After choosing, you pay them according to the SRC rates. They cannot come from the private with their own figures. But in a legal profession, you advertise, they come, then they come with their own figures. They decide their pay. They can say, you have done a case, this case is very complex, give me 243 million, and you are given. So that's why we're saying we need to have what's called fiscal sustainability. Article 130, Article 5 requires us to have what's called to be fiscally sustainable. We can never use our money continuously. So what I'm trying to say is, let us be accountable for the money we have. Why do we say, as Kenyans, let us have a national conversation to ensure that our money is used prudently for ourselves and for future generation. Why is that? As a society, we need to work extra hard to make a society a better place than we found it. Otherwise, we would have failed us as a generation and even future generation. Let us work together, because if we don't, we will always suffer. They always said, the former AG of India says, where the rule of law fails, anarchy starts. And we don't know our country, we need to work together for prudent use of financial resources and ensure that we live this society we are a better place than we found it. So sometimes the county government also have some saying that they don't have capacity. They don't have funds. But the same thing as I've said is also defeatist. For example, the county government of Nairobi, like for example, through what they say that the reason why they are hiring external lawyers is that they don't have money to hire the legal state attorneys. But the challenge is one. For example, they are saying they have 17 county attorneys against almost 1,100 cases. So now they are overwhelmed, which might be true. However, the same county which does not have money to hire county attorneys, they have only 17, they have 21.3 billion to pay external lawyers. Are you seeing? Does that make sense?
No justification.
Not a million, 21.3 billion to hire external advocates. But they only have money for 17 lawyers only. If you add, we're clever people, you can see that they count one's status of issues to be the way they are, so that they can continue hiring external lawyers. That's what we're saying. And we're saying, as a country, we need to stop that.